Today, I'm going to be talking to you about the muteness of an accused person or defendant upon arraignment. So, when a defendant is brought before the court and arraigned, and their plea is read to them, if the defendant stands mute, so the defendant doesn't respond to the plea that has been read, or rather to the charge that has been read, what the court ought to do is to conduct an investigation in order to establish the cause or the reason for their muteness. Now, there are two findings the court may make from conducting this investigation. The court may make a finding that the failure is, the muteness rather, is as a result of a failure to plead, or it may be as a result of a refusal to plead. Now, if muteness is as a result of a refusal to plead, what that connotes is malice. So it means that the accused person has the ability to plead, but has just refused to do so. So he's maybe constituting himself into a nuisance at the trial. So what the court would do in that situation would be to record a plea of not guilty for the accused person and to proceed with a trial. If the reason for the muteness is, however, a failure to plead, now what that connotes is a lack of capacity. It would mean that the accused person has failed to plead because he may be dumb, he may lack the ability to speak, or it may be because he has experienced a visitation of God after the charge was read to him. And when we say he has experienced a visitation of God, what that means is that the moment the charge was read to him, he lost his senses. He has gone, you know, crazy. He has lost his mind. Now, if the failure to plead is because he cannot speak, then his plea would be taken in some other intelligible form. It could be taken in writing, for instance. If, on the other hand, he has just experienced a visitation of God and so he's not in his right senses anymore, he would be remanded at the asylum until such a time when he is now competent to take his plea. Now, if he has been remanded in the asylum and he's now competent to have his plea taken, something that must happen before the court proceedings resume is that a medical certificate must be presented to the court to show that he is now competent to take his plea. If that isn't done, then the whatever conviction may be arrived at the trial will be overturned on appeal. Okay, so that is how the court should handle muteness of a defendant upon arraignment. All right, the court must conduct an investigation to establish the cause of the muteness to see if it's a failure to plead or a refusal to plead. Where it's a refusal to plead, the court enters not guilty and proceeds with the trial. Where it's a failure to plead, the court would allow him to enter his plea by some other intelligible form, e.g. writing, if he's dumb. And if he has experienced a visitation of God, he's taken to the asylum until he's competent to plea again. So I hope you've learned something new today, and I'll see you again some other time. Bye-bye.